Let us now turn to our second panel for today on AI breakthroughs and their impact on human rights. I'll hand over to our moderator without further ado, Mrs. Ariel Conn, the head of the IEEE SA Research Group on Issues of Autonomy and AI in Defense Systems, who will kick off the panel with Andrea Renda, Senior Research Fellow at CEPS in Brussels, among several other hats that Andrea wears, and Professor Reneé Cummings from the University of Virginia. Ariel, the floor is yours.
And good afternoon. I am so grateful to the Athens Roundtable for inviting me to participate in this event. We've had some really interesting conversations over the last couple of days, and it's been fun to be here. So I've been asked to help transition the discussion from AI and defense that we just heard to the potential impacts, the potential human rights impacts of AI. Now, when thinking about AI and defense, it can be easy to focus on potential human rights violations with respect to conflict and warfare, and for very good reason. And that's where a lot of discussions around autonomous weapons do focus. In my own work with the IEEE, we've been looking at how we can address ethical and technical challenges in the development, use, and governance of autonomous weapon systems, with the primary goal of ensuring that if autonomous weapon systems are developed, they meet the standards that are set by international humanitarian law, which is also known as the law of war. But IHL, international humanitarian law, deals specifically with conflict and war, and other international laws deal with human rights in peacetime. And so in our work, we also have a section on non-military use of autonomous weapon systems, because there's no reason to believe that autonomous weapon systems will only be used in military. These are systems that are based on algorithms and software. They can be used to power much smaller systems, and they will be more prone to proliferation. They will be used by private security forces, police, border control, non-state actors, and even civilians. And once a technology is developed, it's very possible that militaries, which tend to be more conservative, may decide not to use a weapon or technology if they don't think it's going to meet the standards set by international laws. But we can't assume that other actors will make the same choice if they're able to get access to these systems. Moreover, even if we establish laws to govern the use of AI and autonomy in wartime, unless those new regulations specifically mention the use of weapons in peacetime, those laws may not necessarily apply to the use of weapons and technologies against civilians outside of armed conflict. For example, the Chemical Weapons Convention prohibits the use of tear gas during conflict, but it does not prohibit police from using tear gas against civilians for crowd control. And finally, we can expect that some of these capabilities that can be used in weapons may be used for other purposes, like drones for mass surveillance or crowd control. And so I'm really looking forward to this conversation to hear from our human rights experts about how we can address these and other potential human rights violations. And with that, I would like to turn this over to Reneé. Reneé, given AI's current capabilities, what in your research are you seeing as the biggest risks to human rights? What should we be prepared for on the ground in terms of those risks? For instance, with predictive policing and surveillance, or any of the other issues that we've just heard about.
Thank you so much for that question. And of course, thank you for having me. It is certainly an honor. I think on the ground, the greatest risk would be questions around autonomy. Autonomy is so critical because what we are seeing would be these opaque decision-making systems, algorithms that are being deployed on the streets and just being deployed in general, really undermining questions such as autonomy and agency and identity development, questions around self-actualization, and of course, self-determination. What we're also seeing is because many of these algorithms are making decisions about our lives and our livelihoods and our legacies without us having much input, much agency in those decision making, we are seeing that one of the greatest threats to human rights is something that we cannot see, which is the question of autonomy. And how do we build technology that is mature and responsible and trustworthy, and a technology that respects questions around identity development, questions around autonomy and welfare and liberty. in particular, the criminal justice system, where we have seen algorithms behaving badly when it comes to the administering of justice, where we have seen the lack of due process because of the atrocity of the black box and the fact that many of the developers of this technology still do not understand why an algorithm makes a particular decision. So often we continue to focus on the things that we can see. We can see, a camera. We can see a mechanism that is, bringing facial recognition into public spaces. But what we're not seeing would be questions around politics of self and identity development under surveillance technology or under the kinds of technologies that are being deployed. So I think the biggest question at the moment would be questions around autonomy, welfare, and liberty within the context of human rights, due process, and whether or not we have the requisite amount of due diligence to really create those rigorous ethical guardrails that are so required at this moment.
Thank you. Yeah, I want to, Andrea, I want to go straight to you because we're looking at the EU AI. I can't talk. The EU AI Act now, and it's identified at least 3 prohibited uses of AI, including mass surveillance by governments. Considering that and some of what we've just heard from Reneé, how will these prohibitions help protect human rights? And are there any blind spots that could potentially result in human rights violations?
Having me, and good to see you as my co-panelists. I'm very happy to be here. The AI Act is an attempt to tackle specific risks that specific uses of artificial intelligence might generate, with a specific focus on a very linear idea of one AI system generating one type of harm to one person in most cases, although the discussions in the European Parliament has gone in the direction of broadening also the notion of harm to incorporate harm to society and harm to the environment. I'm going to get back to this in a second. But that's an important attempt because it focuses on 2 types of risks. One is on safety and security, and the other one is on fundamental rights, so the risks that are more related to human rights. And in that context, what it tries to do is to classify AI systems into different risk baskets, if you wish, in which the core of the regulation is identifying those AI systems that would require specific attention because they can generate significant risks, either for safety, security, or for fundamental rights, and thereby would be regulated. And so how will they be regulated? I can obviously add detail, but I'm not spending too much time here, but there's a series of regulatory requirements. And then there is a category, which is the category of prohibited AI applications, in which basically we see which is, I think, a big achievement of the AI Act. We see a number of potential applications for which I would say there are no known ways of mitigating what is a very significant risk, right? And among those are the techniques and the use cases for AI that you've mentioned before, things like predictive policing or surveillance, although the list is evolving and it's actually expanding as the AI Act is still a pending piece of legislation and it's being negotiated. But why did I start with this linear idea? So first of all, certainly there is a lot to discuss about what happens when an AI application is classified as prohibited, and how is the EU institutions and the member states in the EU, how are they going to monitor and enforce these applications? Where the line can be drawn between what is a prohibited application or similar techniques that are not exactly predictive policing techniques, but still have an element of prediction analytics and things like this. But that said, we do have this initial classification. That said, for me, and I think this goes in the direction of what Reneé was saying before, what the AI Act does not yet do is to think about all the AI applications, be them high risk or low risk, that might interact with each other in the future, creating a web of technological developments around us and potentially create problems of human agency, problems of distancing of the human being from what AI systems decide and suggests in terms of decisions on a daily basis. And so the problem of the epistemic risks of AI, if you wish, the problem of how in an AI immersive world, we will change our way of relating to technology and relating to each other, and how this creates a myriad of opportunities for potentially discriminating people over time. This is not what the AI Act does. So very important piece of legislation, a piece of legislation that it should not be taken for granted, and that identifies red lines, because a week before it was presented by the European Commission, those red lines were not there. But still a beginning, a drop in an ocean of problems that we are about to face going forward. So happy to elaborate further, maybe in the next round.
Okay, yeah, thank you. I want to go back to Reneé. You know, I like the excuse me, the drop in the ocean analogy with, you know, the EU is trying to do some regulation. And Reneé, I wanted to ask you a little bit more about what's happening in the US. So under which conditions would an AI regulation in the US be able to mitigate some of the risks that you talked about? How is the US blueprint for an AI Bill of Rights positioned to tackle those? And drawing from your expertise in data science, do you envision technical limitations to these governance measures?
Again, thank you so much for that question. So we've got the blueprint for the AI Bill of Rights. Of course, it's not a regulation, it's not a law. It suggests a particular way in which we need to audit our algorithms and bring that kind of ethical vigilance, that understanding. The questions around accountability and transparency and explainability are so critical, that auditing is also critical, that accuracy is critical, and that we need to think about protected groups. And we need to think about the ways in which we deploy algorithms and how vulnerable, underserved, high needs, communities are impacted. It also speaks to representation, which is so critical to the ways in which we're thinking about designing, developing, deploying, and of course, adopting AI and algorithms. But there would be no AI and no algorithms without data. And data is most critical to the conversation. So much of the conversation still needs to take a more intimate look at the kinds of data sets that we're using to build these algorithmic decision-making systems. Because the thing that we want from these systems would be accuracy. We want accuracy. Data is about decision-making accuracy. It's about policy. It's about democracy. And the challenge that we are seeing would be that we really have not had the kinds of critical conversations around data, the power, the politics, the kinds of privilege and prejudices we are seeing created. So what we are seeing within the realm of human rights is that question of democracy, that question of decision-making. If we are using these historic data sets in which we are seeing and continue to see the kinds of biases and discriminatory practices that are baked into these data sets, then how are we ensuring that we bring a democratic process to the things that we are doing, the decisions that we are making, the kinds of ways in which we are deploying technology? I think the AI bill of the blueprint for the AI Bill of Rights is critical, it's important, it's definitely a start, and it suggests a particular way in which we need to behave when it comes to the ways in which we are doing AI. What it doesn't do, it doesn't speak to any level of enforcement. It doesn't speak to any level of regulation. So it leaves it up to industry. It leaves it up to the private sector. And we all know that legislation lags behind technology. The law is always late. Technology is always first out of the gate. And that's the challenge that we are seeing, particularly in that human rights context. Whether or not we are thinking about questions around citizenship, whether or not we're thinking about questions around the access to resources that communities need to build resilient and sustainable lives and livelihoods. We're not looking at questions such as legacies. What are we allowing communities to leave back if we are using algorithms to make those decisions? So I think particularly from the UVA context, Our focus has been critical data science. It has been big data ethics, has been questions around data justice, which is so critical to social justice, and of course, design justice, and big questions now around algorithmic justice and how does it intersect with our human rights. So of course, questions such as equity linked to due process, which is linked to the opaqueness of these decision-making systems and the black box. And of course, really thinking about diversity and equity and inclusion and bringing a justice-oriented always and a trauma-informed approach to the ways in which we are thinking about data and using historic data sets to build these decision-making systems. Now, I'm all for AI. I'm committed to and very passionate about the transformative ability of AI to really reimagine every business model in place. And while it can do extraordinary things, it can also do very destructive things. So we've got to think about those data sets. We've got to think about bringing that critical perspective to data science. And we have got to think about questions around oversight, compliance, governance, regulation, and of course, enforcement. Enforcement is what we are not seeing when it comes to regulations. And that's the critical space that we need to continue the discussion in.
Well, coincidentally, that is actually my next question for Andre. I'm kind of sorry that we don't have an entire panel though to talk about all the data issues that you just brought up. But yeah, to the question of compliance and how we ensure these whatever standards we're developing are met. Andrea, in Europe, standardization will play a critical role in how the EU AI Act is operationalized. But some human rights advocates have expressed concern that this may result in a weaker compliance to the AI Act, since the uptake of such standards is voluntary and non-binding. How do you evaluate this issue, and what are possible solutions to overcome risks to enforcement? And are those solutions enough to protect human rights?
Well, let me put it as simply as possible. I agree completely with Reneé of Reneé's concerns. I actually disagree with the concerns expressed in the question on the voluntary nature of standards, and I'm going to explain why. And this doesn't mean that enforcement is going to be easy, okay? So I agree completely with Reneé that the quality of data and the handling of data and the elimination of biases from data as much as possible throughout the process, controlling and mitigating measures in the process of developing, deploying, and implementing AI are key. Also in what is the due process to bring AI in a way that is trustworthy to the market, okay? That said, in the AI Act, this is part, it could be improved over time, but it's part of the regulatory requirements. So the quality of data and the human oversight and a number of these principles are in the regulatory requirements for, not for the prohibited AI systems, obviously, but for the ones that are considered to be high risk. So not the ones that we handle with fear, but the ones that actually we need to handle with care, okay? So handling with care is primarily about data, and it's about accountability, and it's about transparency, and it's about data quality, for which we have insufficient standards at the moment, by the way. That said, once an AI system is classified as high risk, the conformity assessment and market surveillance, let's say the post-market monitoring of the AI system, is a mandatory issue. Now, whether it's done according to the letter of the law or is done or is facilitated by adherence to a standard, this doesn't make the requirement less compulsory, okay? So it is compulsory to comply with regulatory requirements for AI systems that are high risk. Now, in order to facilitate compliance and to reduce regulatory costs, the EU will issue a standardization mandate to the standardization bodies to develop a number of standards that could facilitate for large and small entities that want to comply, that need to comply with the AI Act, to really find references, right? And that said, so the standardization, as voluntary as it might look like, it's actually going to be compelling for many entities in the market. So I don't see a big problem there. Where I see the big problem is who's going to actually be able to enforce, so to monitor that there is actual compliance with these standards, and whether the letter of the law will be sufficient for the next 2, 3, 4 years to understand what are good risk mitigating measures, what are good standard compliance measures, and so on and so forth. My answer is no, and I'm going to be very brief on this before you get worried, Ariel. My answer is no, in the sense that what is most important about a piece of legislation like the AI Act or the blueprint for an AI Bill of Rights is not what is written in there, which is already very important, but what comes next. Who, in terms of a governing entity and oversight body, is going to continuously refresh the state-of-the-art knowledge that is needed and give interpretive guidance to the ones that need to comply with legislation on what techniques are of concern, on what mitigating measures and good data governance and handling measures are state-of-the-art. And so how these standards can be made sort of almost updated in real time, if you wish, or updated very frequently, because otherwise they remain very static references that might end up providing perverse incentives to the market and thereby generating more risks than the one they are supposed to mitigate. Back to you, Ariel.
Okay, thank you. All right, in the interest of time, there's still a couple questions that I did want to touch on. So we'll try to get through these quickly. We've been talking a lot about what's happening in the EU and in the US, but there is a whole world out there. So Reneé, I want to go back to you. How can we ensure international cooperation and coordination so that AI governance measures from regulation to standards can truly be aligned to human rights? And what are the impacts of those efforts for the Global South?
Thank you again. I think the challenge we have right now would be the challenges around data literacy, AI literacy, and futures literacy, because we speak a lot about AI. And one of the things that we've got to remember, it's just that, all geographic spaces are not experiencing AI in the same way. Exactly when we think about data, different communities experience data differently. And we're seeing that more and more because we are deploying technologies that may not be sufficiently mature to deliver on the promise when they come to market. I think what we've got to realize is that we need to have conversations around data, conversations around AI, conversations that speak to those ethics. We need to focus more on questions around justice and equity and diversity and inclusion. We still have not come up with a formula for an inclusive technology or a formula for making AI more diverse. And what we've also got to understand is that we've got to do things that are culturally appropriate and culturally relevant. And we've got to understand, how other societies are experiencing data and experiencing the deployment of AI in those spaces. So of course, conversations like these are very important, but we've also got to understand in the Global South, in many countries, these conversations have not started. Some of them still have not really come up with a definition of what digital transformation is supposed to be. But what we do know is across the globe, individuals are using technology. They don't understand what's happening with their data. And not only is the data being monetized by many of the big tech companies, but this data could also be weaponized. And this data is also being optimized when it comes to the optimization of oppression. So I think what we do need is to really have a way in which we can bring to this sort of table that we speak about, that level of diversity and that level of conversation that is so critical. I think for a lot of individuals is that because we cannot conceptualize data, because data is not something that we can see, we often don't understand how powerful it is. And I think the other challenges that we would be seeing would be questions around ethics. We still have not come up with a formula as to what an audit of an algorithm actually looks like within a standardized sort of practice. So there are so many challenges. So questions such as those are amazing, but at this stage, it's almost impossible to think about how do we do all those things, because in the US, we've not figured it out. In the EU, it's still being figured out. And while we are figuring this thing out, we're thinking about how do we figure it out for other demographics. So I think when we come back to this question of data, We've got to come back to questions around, for me in particular, questions around indigenous data, questions around communities understanding that they are not the consumers of technology, but they are the producers of knowledge through data. So there's so many questions that just need to be had. But I think if we begin with the question of ethics, and we use ethics as a platform to the ways in which we want to get things done, and we respect questions around agency and welfare and liberty, and we understand why justice is so critical. I always speak about bringing that trauma-informed approach to the ways in which we are using data, and just a particular measure of understanding always that different communities have historically experienced data differently. And if we want to bring that equitable social justice approach to the things that we're doing, and we want to include the Global South in that conversation, we've got to include them in a place that allows equity and not, continue often as we do with a very paternalistic approach to the ways in which we embrace the Global South. So I think there's much work to be done. How that work is going to be executed is the challenge that we have before us.
Well, thank you. We've only got like seconds left, but I do want to try to get one last question over to Andrea. And Andrea, you won't have much time, but here you go.
Okay.
What is the role and challenges of the Trade and Technology Council Trade and Technology Dialogue in fostering transatlantic coordination for AI systems, particularly for human rights protection, and specifically regarding standardization and influencing a global uptake of trustworthy AI?
Well, first of all, I'll try to be super quick. I want to echo what Reneé was saying. I'm dealing with the issue of the Global South and AI, and I'm trying, and I'll say this very quickly, to convince EU institutions in particular in the new infrastructure and investment initiative and the Global Gateway to prioritize solutions that create and value at the local level and enable local communities to retain value and data at the local level, and prioritize data literacy, data stewardship competences at the local level. And that rather than really paving the way for data grabbing business models, which is what we have seen in many cases until now. So +1, and plus I think many others, I see that in the chat for Reneé on that. In the TTC in a few days, Sunday and Monday, you should expect a statement on AI in which the US administration and the European Commission agree to embark into a convergence path on a number of definitions and numbers of frameworks for assessing and measuring the risk. That is, in my expectation, something that will be mediated over time and made a little bit broader, a lot broader than the pure transatlantic relation by the OECD network of AI experts and also other initiatives such as the Global Partnership on AI. In particular, the OECD network of AI experts that have set up a specific working group on risk measurement and definitions that I have the honor to co-chair. And so we'll be there to try and make that first bit of convergence happen. But I think the convergence of definitions and standards is not as important as it is the deployment of AI in a way that is inclusive, not only of the global north, but it creates value and empowers communities and regions in the global south.
Thank you. I
Well,
will
thank you
pass
all.
this back.
Yeah, thanks a lot, Ariel. And thank you, Andrea and Reneé. Quick plug, and I see that Arno has linked, has given the link in the chat towards the Global Partnership on AI project on data justice to build upon some of the points that you raised, particularly you, Professor Cummings. Thanks a lot for being with us and for this deep conversation. We couldn't cover it all, to be continued.